Ready, start. This court's identification of double inverted comma poor agricultural workers double inverted comma close as the double inverted comma weakest sections of society double inverted comma close established the jurisdictional boundary of relief. Subsistence farmers dependent entirely on inherited land face destitution when acquisition bypasses mandatory safeguards. They possess no alternative livelihood, lack resources to navigate administrative procedures, or afford prolonged litigation. The remedy provided by this court addressed this structural vulnerability. Notably, the aforesaid classification carries decisive legal significance by grounding relief in structural incapacity rather than extending automatic restoration to all affected parties. This court prevented undermining finality in land acquisition proceedings while ensuring protection for the genuinely defenseless. Extraordinary judicial intervention is warranted when systematic barriers prevent certain classes from accessing ordinary remedies, not when parties possess adequate means to vindicate their rights. Relief conceived to prevent impoverishment among the disadvantaged cannot extend to commercial enterprises with financial capacity and institutional sophistication. Against this backdrop, we have no hesitation in holding that respondent number one falls squarely outside the protective framework envisaged by this court. Unlike marginal farmers facing potential destitution from loss of their sole livelihood, respondent number one operated a 60,000 square feet manufacturing facility employing over 100 workers since 2003, having purchased and converted agricultural land for commercial purposes. The origin of the litigation further reinforces this distinction as the proceedings before the High Court commenced through a PIL specifically initiated to prevent poor farmers from losing their fertile agricultural land. The express objective of PIL was to safeguard cultivators whose livelihoods faced extinction through large-scale acquisition. Extending such relief to industrial entities like respondent number one would thus defeat the remedy's foundational intent. In view of the above analysis, we hold that the reasoning in Kedar Nath Yadav within bracket supra bracket close does not inure to the benefit of respondent number one. The restoration remedy was conceived for disadvantaged farming communities, not as general restitution for all affected parties. Beyond this distinction, we are constrained to add that even the established procedural principles preclude respondent number one's claim. Orders quashing acquisition proceedings may operate either in personam or in rem, where the court quashes acquisition on grounds personal to individual objectors such as vitiated consideration of their specific objections under section 5-A. The relief operates in personam and benefits only those parties who contested the matter before judicial forums. On the other hand, where the court declares the entire process void ab initio on grounds going to the root of acquisition, the relief operates in rem. It is thus clear that the benefits of quashing do not accrue to persons who were not parties unless the court has struck down the entire acquisition on fundamental grounds applicable to all. It may be opposite to observe here that the objections under Section 5-A raise issues personal to each landowner. Upon rejection of such objections raised, the aggrieved party must approach judicial forums to challenge the same, and mere filing of objections does not exhaust remedies available in law. To further simplify, claimants who do not file objections or pursue judicial challenge cannot contend that Section 5-A inquiry is vitiated.